Welcome. This presentation is available for MCLE self-study credit. If you would like to receive credit, you must take 3 actions. First, click Show More text below on our YouTube page. The text will expand and show a link to download the handout materials. Once you finish watching this presentation, please click the quiz link to receive self-study credit. Once the quiz is successfully completed, you will receive a certificate via email within 72 hours. We hope you enjoy the presentation. Thank you. Thank you, everybody, for joining us today. Again, I'm Katie Jones with ADR Services, Inc., and it is my distinct pleasure to introduce our panelists for today's presentation. Going alphabetically, let me begin with Richard Collier. Mr. Collier has been in practice for more than 40 years as a trial lawyer and over 25 years as a mediator and arbitrator, mediating or arbitrating to completion over 400 disputes across a wide range of civil law, ranging in complexity from smaller value disputes to large multi-million-dollar settlements. Mr. Collier prides himself upon thorough preparation of the participants as well as of himself. He has proven to be particularly effective in disputes encumbered by high emotions. His respect for the emotional dynamics between the parties, as well as his thorough understanding of the facts and law, allow him to build credibility with the parties and their counsel while crafting settlement scenarios to ensure resolution. Welcome, Mr. Collier. Next, we have Judge Jamoa Moberly. After a successful career as a litigator and trial lawyer for 20 years, followed by a distinguished and diverse career as a judge for 21 years, Judge Moberly returned to her roots in alternative dispute resolution to serve as a mediator, arbitrator, and referee with ADR Services, Inc. As a foremost civil litigator and trial lawyer, Judge Moberly handled and resolved cases across many areas of law. Judge Moberly brings a caring attitude to dispute resolution, grounded in her goal to empower the parties to reach a resolution which is creative and satisfying. Especially applicable to trust and estate issues, her process is to listen to the parties, understand their perception of the facts and issues, educate them as to what may appear to be paths to resolution, and help each side bridge their differences. Thank you for joining us, Judge Moberly. Next, we have Judge Mary Fingal Schulte. Judge Schulte retired from the Orange County Superior Court in 2017 after 20 years on the bench. For the last 14 years of her judicial career, Judge Schulte held various civil assignments and presided over the general jurisdiction civil trials, probate and mental health hearings and trials, appellate panel hearings, and long-cause family law trials. As a neutral, a large portion of her practice consists of probate and family law matters. She generally takes a facilitative approach to mediation, and with her even judicial temperament, she regularly resolves complex and emotionally charged matters, either during the session or through stalwart follow-up. Thank you, Judge Schulte. And finally, last but not least, we have Judge Paul Suzuki. In his final assignment as a judge of the Los Angeles Superior Court, Judge Suzuki served in the probate department, overseeing a wide range of probate-related matters. While presiding over long-cause probate trials, he tackled some of the court's most challenging and demanding trials, lasting 5 or more days. Judge Suzuki has extensive experience in nearly all trust and estate-related matters, including various petitions for will contests, trust disputes, breach of fiduciary duty, undue influence, and financial elder abuse, conservatorships, guardianships, and real property claims. Judge Suzuki joined ADR Services, Inc. this year and is available for mediation, arbitration, private trials, and discovery references. Thanks so much for joining us, Judge Suzuki. All right, without any further delay, I will hand it over to our wonderful presenters to get us started.
Okay, that's me, Katie. You can go on to the next slide. All right, good morning, or actually afternoon, everyone. I will be talking about obligations and duties of the fiduciary, and I wanted to thank you all for joining. I always find it a little disconcerting speaking on a webinar because I can't see any of you, and part of what I love about speaking is looking around and the eye contact, but in the participant feature, we who are on the panel we can see who everybody is, but there's 317 participants right now joining in, and I think a total of 544 registered. So I've kind of taken a quick look to see who's out there. I recognize some names. A lot of you that I know are very experienced probate practitioners, and we probably got a lot of fiduciaries out there. attorneys new to probate and trust, and attorneys who are wondering if they want to come into probate and trust. So we panelists recognize we've got quite a mixed audience. And we have 4 separate topics we're going to be talking about and limited time to do it. So each of us, myself included, in about 12 to 13-minute presentation will give you some basics, not all you could know or hear about this specific topic. Probably each of our topics could take up a good hour. So apologies if it seems like we're going too quickly or we're not covering enough material. But one of the things that I love about speaking in MCLE type venues and also attending is I always learn something. So I just encourage all of you, if there's a lot of new stuff, just look for a few what we call nuggets. And if it's a lot of this stuff is old hat to you, because I know there's some people out there that have been doing this a lot longer than me, still, I'm hopeful, and we're all hopeful, that there will be at least a couple of things that are new to you and or reminding you of information that you might have forgotten about. Katie did mention the Rudder Guide, and I wanted to emphasize that again too. Shout out to Rudder for allowing us to have that as part of the handout materials. It's 83 pages of materials, and it's really good. I was reading some of it last night again, and one of our own neutrals, Bruce Ross, was co-author of that. So I might be referring to the Rudder Guide a few times during my short presentation, but I encourage you to make best use of that. So I'm talking about obligations and duties of the fiduciary. As I said, there's a lot of powers in the probate code of fiduciaries, and I'll be touching on that a little bit, but mostly going to focus on duties. So if you're wondering why I'm skipping things, that's why, limited time. So Katie, you can go ahead to the first slide, since I have no power over that. So probate code section 39 defines a fiduciary as a personal representative, trustee, guardian, conservator, attorney in fact under a power of attorney, custodian under the California Uniform Transfers to Minors Act, or other legal representative subject to this code. And the commentary to section 39, which I'm not going to read, talks about important differences, because this is a lot of different kinds of fiduciaries. And what our program, and my talk especially, is going to focus on in the capacity of somebody who's a personal representative and a trustee, rather than conservators and guardians, because that's really a lot of material to cover. So that is going to focus my material. Katie, next slide. Just some real quick slides here. We're not just talking about private professionals in our 4 sessions, but I thought it was worth at least mentioning the licensure requirement under the Business and Professions Code. That's 6530, which now has been in effect for 9, 10, 11, 12, 13 or 14 years. 13, my math's bad. So beginning January 1, 2009, and that was the day well, that was a holiday, but at least shortly after that, I took over the Orange County Probate Department as a supervising judge, and this licensure requirement had just gone into effect. No professional fiduciary can operate on an expired, suspended, or revoked license, and anyone holding themselves out as a professional fiduciary must be licensed. You can't hold yourself out as one unless you're licensed. But there is an exception, an attorney, because attorneys, as those of you who are attorneys know, have a host of other licensing requirements and obligations imposed by statute and by common law. So next slide. I like how she fades in and fades out. What is a private professional? 6501 of the B&P code. A private professional is a person who acts as a trustee, agent, under a durable power of attorney for more than 3 people or families at the same time. And I stopped there when I was rereading this for the umpteenth time. I thought, because guess which child of 10 that my parents had, who's the retired judge, got to be trustee? over the family. And I thought, well, I'm not a private professional. So the next line is not related to the professional by blood, adoption, marriage, or a regular domestic partnership. So if you're a trustee or a personal representative and you're managing a number of people like I did, or families, but they're family members, then you're not a private professional. So hopefully that's pretty clear. Next slide. Private professional exceptions are listed in 6501 of the probate code as well. And so if you're a trust company, a bank, or employees of same county, California state or county public agency, such as the public guardian, and also I dealt with public administrator a lot, or a broker or dealer registered under the securities law, you're not considered a private professional under the B&P code. For the public, there is all of these entities have are regulated elsewhere, and I'm not going into all that, but it's everybody's protected even by these type of fiduciaries. They're just not within the private professional licensing requirements. Next slide, Katie. Then there's fee disclosures, 6563 of the Business and Professions Code. So this is if you are a private professional fiduciary, and if you have a website, and who doesn't, but some people don't. But if you have a website, must post range of fees charged. If you're a private professional fiduciary and you don't have a website, you must provide the prospective clients with a written range of fees prior to contracting for services. So next slide, Katie. Now we're going to get into the meat and potatoes, so to speak, of standard of care. So I'm going to be talking about two basic standards of care in my presentation, and I forgot to turn my timer on, so Katie will keep me timed. Trustee and personal representative. So the personal representative standard of care, known to many of you, is set forth in 9600 of the probate code. Personal representative has the management and control of the estate. In managing and controlling the estate, I have 4 minutes. You must use ordinary care and diligence, and that's determined by all the circumstances of a particular case. Next slide, Katie, since I don't have a lot of time, I guess. So the personal representative shall exercise the power to the extent ordinary care and diligence requires it to be exercised, but not exercise it to the extent the standard of care requires it not be exercised. In other words, in summary, if you've got the power, it doesn't mean you have to or should exercise it, or that you shouldn't. So it's very fact-driven. All of these types of things, when they come to the court, are very fact-driven, and it's under the circumstances of the particular case. Next slide. Trustee standard of care is set forth in Probate Code section 16040. I had a lot more to say about personal rep, but I'm running out of time. So standard of care is, I'm not going to read it all. You can read it. The trustee does have a lot more powers, so there's a lot more regulation on the standard of care. 16041, which isn't on the slide, but I thought that was worth mentioning. Whether the trustee is being compensated or not does not affect standard of care. So the fact that you're working for free or working for lots of dollars, same standard of care. It's an objective standard of care. Section B allows the settlor to expand or restrict the standard of care under the circumstances. Another code section worth mentioning is 16014, and that's not on my slides, but the duty of a trustee to use special skills if the trustee holds him or herself out as having special skills in a particular area. So there's that duty. I did want to talk about 16440B really quickly, not to impinge on Judge Suzuki's area, but that is really an important code section for the court and for litigants. It allows the court to excuse the trustee if the trustee acted reasonably and in good faith. A case citation that I really would encourage you reading is the Orange County Catholic Foundation versus Arvizu. It's 28 Calap 5th, 283, and that's a 2018 case. And I just want to read a little bit from it. So how could Arvizu in good conscience boot out a man who essentially was a member of her family, lived in the house for 40 years, suffering from dementia, and had minimal financial assets? Under the circumstances, it's hard to imagine that anyone would take that step. This was an affirmation of a decision by Judge Claster, who found there were technical breaches of duty, but as you know, in probate, the court sits in equity, so the court can weigh the equities. And I love this line. He said, while the statement might be technically correct, it strikes the court as both unrealistic and not particularly charitable to boot out this person who was a family member. So I think that that's a good case to read in terms of standard of care, fiduciary duty. Next slide, Katie. Uniform Prudent Investor Acts. That's Probate Code Section 16046 says that a trustee who invests and manages assets owes a duty to beneficiaries to comply with Section 16047. And in the interest of time, I'm not going to read the whole thing. I don't have Section C. I'd encourage you to read that. That lists the circumstances, 8 of them in particular, to consider in making investments and in managing assets. There's also 16048. The trustee has a duty to diversify investments unless, under the circumstances, again, objective standard, it's not prudent. 16047 has a lot in the commentary about standard of care under the Prudent Investor Act. And again, I apologize that we're just kind of having to skip through stuff, but we're giving you the nuts and bolts of it. And finally, almost finally, this is what I call the punch list for the trustee's duties in general. Duty to administer the trust according to the instrument, solely in the interest of the beneficiaries, duty of loyalty, duty to avoid conflicts of interest, control and preserve trust property, make the property productive, and so forth. Then there are discretionary powers under 16080 to 082, and 16081 says that subject to additional requirements of other subsections. And this is important. If a trust instrument, because you've probably seen them, confers absolute or sole discretion, uncontrolled discretion on a trustee, the trustee still must not act arbitrarily. The trustee must still abide by the standard of care, can't act in bad faith, can't ignore trust purposes. Next slide. Maybe the last slide, I think. All right, 16202 of the probate code has a corollary for the personal representative. I think it's 9606 or somewhere in there. The grant of a power to the trustee. In other words, if the trustee has a power, that doesn't mean trustee must exercise that power. So, I mean, the takeaway is the trustee has to use discretion, has to be mindful of fiduciary duties, cannot act in bad faith. I have a lot more to say on this topic, so maybe at some point I'll do a 1-hour presentation. But with that, after the trustee and personal representative hears about all this stuff that they have to do, how are you going to find somebody to take the job on? And that's what my brilliant colleague, Mr. Collier, is going to address.
Thank you, Judge. Even the briefest review of the obligations and duties of a trustee show that it's not for the lazy or for the faint-hearted. The formal qualifications for being a trustee are minimal. Basically, you have to be a grown-up. But, and I've seen many trustees in action, the personal qualities and capabilities that make for an effective trustee are demanding. From observation, an effective trustee, Katie, if I could have the slide, is one who is competent to handle the trust's finances. Next, has administrative capabilities and resources, is able and willing to follow the trust's instructions, is familiar with the beneficiary's circumstances, personalities, and abilities, is unbiased and sensitive in making decisions, is alert to and unfazed by family conflict, has the time and the interest to serve as trustee, is sensitive to the costs of administration, has good judgment and common sense, and given all those, this is my own, must have a sense of humor. A family member, the family accountant, a professional fiduciary, a bank. I have seen them all work well. I've seen them all flounder and worse. And all too often, the considerations that favored the selection of the trustee turn out to be liabilities. For example, next slide, Katie. Familiarity with the trustor and the beneficiaries. That criterion should perhaps argue for a family member or an advisor who's been working with the family and is trusted by the family, someone who's familiar with the family circumstances, the family business, the family history, the family problems. But that very familiarity might also be an obstacle in following the trust's terms. How often have we heard, I agree, Michael will simply waste the money if he gets it now. Or Dorothy really wouldn't have wanted that to happen. So familiarity with the family can often raise obstacles for handling the family affairs within the trust. Next slide, please. If one criterion is administrative abilities and resources, that might argue for a formal bank or a professional fiduciary, especially where the assets are complex and need constant managing. One of the burdensome duties of a trustee is to report to the beneficiaries, and the professional fiduciaries and banks have the capabilities to do that. But there's a downside. I represented a Midwestern bank in litigation recently, and we had to do an email search for document production. The plaintiff was a single widower, and he had one computer to go to. The bank that I was representing had been the trustee for 3 years. I had 49 different emails that I had to go to, 49 people that handled the trust in a 3-year period. So layers of accountability lead to impersonal complexity and turnover. Next slide, please. Cost considerations, again, perhaps a double-edged sword. A professional fiduciary is obviously going to charge a fee, and that fee could be substantial if the assets are significant. But an individual family member trustee is also entitled to charge a fee in California, not true in all jurisdictions. But there are problems. An individual trustee who has to work hard might get resentful if he feels as though he should not be charging a fee. Or it might cause resentment if they do decide to charge a fee. And a responsible trustee will also incur cost considerations, consulting with investment and tax advisors, and all too infrequently with conflict management experts. So there are not surprisingly, no hard and fast guarantees that a particular trustee will work. But the best advice I can pass on, it comes from a mediation I handled a few years ago. The mediation involved a successful executive of a Midwestern business, married with 3 children. His wife for many years had suffered from a debilitating illness. And the executive developed an intimate relationship with his executive assistant, spent periods of time living with her, went on vacations with her and his children. He died unexpectedly. He left a family trust with 2 daughters as the co-trustees of the family trust. But he also, and this came as a surprise, left a trust for his consort, for his executive assistant. And the trustee of that trust was his son. The children challenged that trust, arguing, amongst other things, that it hadn't been properly funded. And she, in turn, sued for a Marvin versus Marvin kind of claim against the estate. There was extensive litigation when the case came to me for mediation. The lawyers involved were very good lawyers, but in this particular case, they wanted to protect their clients from me. They kept them from me. And I had a hard time getting through to the clients to work with them. So at one point I called a break in the proceedings. We had a bathroom break. And as we were on the way back to the conference room, I saw the son. And I said to him, "Why do you think your father made you the trustee of his assistant's trust?" And he stopped in his tracks and he looked at me and his eyes began to brim with tears. And he said, "He chose me as trustee because he thought I would do the right thing." That's the best advice I can pass on in choosing a trustee. Choose someone who is going to do the right thing. I mentioned the mediation I handled. The next topic we're going to cover is the role of the trustee in mediation. And for that, I'd hand over to Judge Moberly. Thank you.
Thank you, Mr. Collier. Okay, my discussion will be from essentially now retired judge sitting in mediation in trust litigation and the insights I've gleaned both on the bench and also sitting as a mediator. Next slide. I've included Probate Code 16040 as a reminder. This has already been discussed by Judge Schulte, but approaching mediation, all the obligations and duties as a trustee come with you, both in scheduling, preparing, and participating in the mediation. And you've got, your obligations to the trustor, following the trust, and to all the beneficiaries. And I'm referring to the trustee's role. And quite often, and usually, the trustee is also a beneficiary. So, next slide. That brings us to deciding when and if to have a mediation. For instance, don't waste trust assets by setting a mediation at the wrong time. For instance, if you have no action pending and the mediation is to force a distribution, there may not be the clout or impetus to actually bring it to a conclusion. So think about that. Once again, it's great pressure and obligation to conserve trust assets. The other aspect is coming prepared to the mediation. And don't think that you've done your job and everyone else is going to sort of come along with you. Again, you have great obligations and of course, as counsel for the trustee to come fully prepared. And this brings up the Breslin case. It doesn't apply to all matters, and you should really study Breslin and how it's been revisited in preparing and scheduling the mediation. But it's wise to just give notice to all the prospective beneficiaries. Many may be unrepresented, and they might, as has happened, with ADR services, we'll get calls from unrepresented beneficiaries wondering why they've gotten notice of this mediation. And some choose to come, some do not. But it's wise as trustee to make sure you have addressed the Breslin case. Before mediation, I found it's really effective to prepare a draft plan for distribution. Hopefully it can be circulated to all the prospective beneficiaries, but it may be best in many cases to just circulate it to those who are represented by counsel. And it gives you a framework, gives them time to consult with their clients, but it's really food for thought. Because bear in mind, from a mediation viewpoint, we're really seeing the cases where there is a problem that they're not able to really handle the management and distribution of the trust without additional help. I remember when I came to probate that attorneys would tell me, well, you're only seeing the 10% of our cases. 90% go just fine. But this is to help you, hopefully, to avoid being that 10% too. It's also really helpful in almost every mediation to come with a bare bones draft settlement agreement. In the trust situation, it really should be the trustees council who has prepared that. They're getting compensated out of the trust to do so, and then work with the other attorneys. And I suggest, if possible, to circulate that before you come to the mediation. Same thing applies, of course, to settlement briefs. Day of mediation, what should the trustee come with? Well, first of all, most obvious, and quite frankly, because often you've got the accounting that's being contested, come with the current financials. It doesn't have to be a hard copy. Just make it readily accessible if someone wants to pull it up on one of the laptops. Come with information regarding all of the pending fees. How are there, for instance, trustee council, what fees are still outstanding? What do you anticipate in the future in order to really bring the trust to a close? Of course, there may be litigation out there. What I have found really helpful is when you have real estate that potentially needs to be sold, bring a short list of realtors that you have vetted who potentially will take on the listing, and have them available by phone if necessary. So you can reach an agreement with all of the beneficiaries at the mediation, and you can really move on this. And this is really important too in this situation where you have bilingual clients. So you obviously want to have a realtor who can communicate in their native language. Again, they'll be more effective and build trust. If you've got a business, that I've seen this, cases where the trustees not well experienced or trained, son might be managing a very should be lucrative mobile home park or apartment building. Come with the list or one or two at least professional managers that you can propose to take over management of that property. This can cut some issues off of the pass and be grounds or to reach a resolution that might be stemming from that management. And of course, bring your inventory of personal property. What are the items that are going to be addressed that you need to have a reserve held back for? And why do you need the reserve? Trustee needs to answer and come prepared with all of that. And regarding the real property, and we've all done this, you see a property and then you pull it up on Redfin or Zillow and you think that's the value. Well, it's really better to come with an appraisal for the real property, or if you have other very expensive tangible property, come with the appraisal. And have your trust accountant on call. Again, not all trusts require this, but some do. And most of all, wear the neutral hat. Take off the beneficiary hat and just come as the neutral. Next. Co-trustees. Is this a good solution? Often it's seen as either in drafting an agreement or early on or even midstream as a way to resolve some conflict. But you might solve one issue and create others that could cost a lot for the trust, because some co-trustees may only communicate by email. They will set up barriers and they will have their own counsel. So you have at least double the expenses for the trust. Next. And this, of course, brings up the issue of professional fiduciary as a good solution. The obvious, not a beneficiary, no family history, assures one set of attorneys, and it could be quite reassuring to the unrepresented beneficiaries. Of course, obstacles, your estate may be too small, it may be very illiquid, and of course, the trustee or co-trustees may not voluntarily step aside. But I've seen this used effectively, and it may be very late in the trust management, and I've seen them in mediation when they've stepped in and we've resolved the case. Next. The mantra for the trustee in approaching mediation is to do no harm. Come prepared, essentially with your bag and issues of low-hanging fruit that you can reach an accord on short of full resolution, because this will instill confidence in mediation. You won't make things worse by going to mediation if you haven't reached a full resolution. And on the other side, as a trustee, you have knowledge of the guest territory, whether you're a family member or professional fiduciary. Evaluate whether or not there are some relationships that are salvageable. It may be a very long time until that truly occurs, but think of how you can build some bridges. My personal mantra regarding settlements and mediation is peace with honor. So build that bridge for who might be perceived as a loser to walk across in the future. And one of the vehicles for this is perhaps a shared task in the short, near-term future. It might be a memorial could be return of some memento, and it could even be an apology, or in some cases, simply recognition that for the efforts that someone has exerted. It's just really showing appreciation. So, and thank you. And now I turn the mic over to Judge Suzuki, who would tell you the other side.
All right, thank you, Judge Moberly. Good afternoon. It's good to be back with you folks again. As you recall, I did sit in Department 79 and Department 3 long cause in downtown LA, so it's good to be with you again. So my topic is the grounds and procedures for removal of the fiduciary. And I'm going to break it up into two segments. The first one is going to be in a probate setting, and the second one is going to be in a trust setting. Katie, next slide, please. Now, the grounds for removal is contained in Probate Code Section 8502. Did the current representative commit waste, mismanage, embezzled, created fraud on the estate, or is the personal representative incapable or incompetent or not qualifying? I like to say that sometimes these wills were drafted about 40 years ago, and now the proposed representative is now 90 or 100. And it's not really too favorable in terms of maintaining bookkeeping and keeping organized. So that does occur. Other times we have another ground is neglected the estate or neglected to perform. I'm not going to get into that. I think Judge Schulte explained all the duties that were required of the representative very succinctly, and check that punch list that she referred to. Also, removal is necessary for the protection of the estate or interested persons. That's a pretty much open-ended ground. So I would say that if you have good cause to certainly assert other facts, you may do so in your petition. Next slide, Katie. All right, the grounds and the method of removing someone in a probate setting is found again in 8500 at SEC. Any interested person may file. Now, I'm not going to talk about the Barefoot versus Jenkins case. That was a big dispute back 2 years ago. But basically, any interested person who might have had an interest in a probate estate, or they got excluded because it was rewritten, or there's an allegation of undue influence, certainly the Barefoot case laid that to rest. So we're not going to get into that today. The petition may be combined with requesting a successor. Many times the court has seen a petition would have other causes of action or requests for relief. That would include a surcharge request or an accounting, as well as designating somebody who might be the potential successor. The court can do it on its own motion. The court can suspend powers pending the hearing and make other orders regarding the property pending the hearing. For example, the court could make an order prohibiting the probate representative from transferring the property or encumbering the property or in other way dissipating the estate. Court can also appoint a temporary representative if the powers are suspended. Probate Code Section 8540. Also, the appointment of a special administrator may be made at any time without notice or on such notice as the court deems reasonable. Probate Code Section 8541. I think most judges want to have due process occur, so in all likelihood, they would probably favor a notice, but I could see in a rare circumstance where the probate representative, somebody catches wind that person is going to go to Las Vegas and there's some liquid funds of $85,000, and there's indication that person is not coming back, that you may not want to give that person notice that you're going in to revoke that person's power or at least suspend it and tie up the bank money. Next slide, Katie. Now, when you file the petition allegations should have issues of or state standing, the name of the representative to be removed, and the facts and not conclusions. Number two, the opposing party can file a demur. I would suggest to you that that is highly not favored by the courts. Basically, if it was granted, the judge would probably give some time to file an amended petition. So make sure you comply with the meeting confer and see if you could try to work it out before you spend $1,000 to $2,000 in filing that demur. Okay, number three, keep your probate attorneys and probate examiners happy. Make sure you use the Judicial Council Form DE 122 citation form. Okay, number four, mail a copy to the bonding company. Number five, the matter shall be set within 10 days unless the parties agree otherwise. Now, that's going to be a little tricky. As some of you know, in downtown LA, the probate calendars are pretty backed up as a result of COVID. And so you may have a situation where the judge might have 50 matters calendared on that 10th day that you filed it. So you might have a problem having the hearing actually heard during that 10 days. Certainly you have a right to have it set, but I'm not sure whether it'll be heard. The situation is that you could ask for temporary relief or temporary supported by declarations to suspend the powers while you're waiting for that hearing. Next slide, Katie. Now, there is a risk in filing the removal petition. Keep in mind, Probate Code Section 9614C, that if the petition is brought unreasonably and for the purpose of hindering the personal representative, the current representative could seek attorney's fees against the petitioner. So I'm sure that in most cases, most of the attorneys have a reasonable grounds to file these petitions, and occasionally, and more so in the area of impropers, where you have fighting siblings who are doing passive aggressive things against each other, might get a little too emotional and file a petition to remove without having any substantial grounds. And that person, after being battered in court, would come knocking on your office and says, you know, I think I need an attorney now. So I think it's incumbent upon you to really examine the facts, and make sure that you're on good ground and that there is a reasonable belief that and facts that somebody should be removed before you follow up on that. Our next slide, Katie. Now we're talking about the good, bad, and the ugly. The successor personal representative may sue attorneys hired by the predecessor representative. So I wanted to talk about landmines and war stories. I had a case where there was a substantial amount of money in the trust or in the probate estate. And there was probably at least 8 law firms who were successfully substituted out. And 5 of those law firms, and these are major reputable probate law firms, were getting sued by their own client for legal malpractice. So the lesson is that if somebody comes knocking on your door and you see that this individual client had like 7 or 8 prior attorneys, you better think twice about taking that case. I think Judge Moberly had mentioned in Orange County, she saw at least one case with about 10 or 12 attorneys in that litigation. So just be careful out there. Our next slide, please. All right, so moving on to the removal of a trustee, that's contained in Probate Code Section 15642B. That sets forth 9 grounds. Number 1, the trustee has committed a breach of the trust. Number 2, the trustee is insolvent. Number 3, hostility or lack of cooperation among the co-trustees that impairs the administration of the trust. 4, the trustee fails or declines to act. 5, the trustee's compensation is excessive. 6, the sole trustee is a disqualified person. 7, the trustee is substantially unable to manage the trust's financial resources or properly execute the duties of the office. 8, the trustee is substantially unable to resist fraud or undue influence. And number 9, the all-encompassing flexible clause, any other good clause that you might assert for removing a trustee. right, next slide, Katie. Now, the procedure would be to file a petition under Probate Code Section 17000, setting forth all your allegations. Next slide, Katie. And keep in mind that the court has broad powers to supervise the trust. There's a lot of case law that talks about that the courts are acting as a super fiduciary. And if you review Probate Code Section 17206, that's the judge's friend in terms of the powers that enable the probate judge to broadly impose any type of order. And I'd like to read it. It's only a couple of sentences. 17206 states the court in its discretion may make any orders and take any other action necessary or proper to dispose of the matters presented by the petition. So if you have some other novel ideas, you certainly could present it to the judge and indicate to the judge that the judge has the power under 17206 to order that. So some of the other orders include the appointment of a temporary trustee. The court may sua sponte order an accounting. The court may appoint a trustee ad litem to conduct litigation when the trustee has a conflict of interest because he or she asserted a claim against the trust, which was inimical to that of the beneficiaries. That's the Getty case. That happens quite often sometimes. These cases are primarily intra-family, and usually the trustee is a family member and might be fighting another beneficiary. And in doing so, he might or she might end up increasing the amount of distribution to the trustee because that person is wearing two hats, the trustee and the beneficiary. So you might want to consider having a co-trustee for the specific task of only handling that litigation under Getty versus Getty. And also the court can settle the account, fix the compensation, and the court can do this without waiting for any beneficiary to petition for removal or suspension. That's the Schwartz matter. And that's a confirmation that the probate court is acting as a super fiduciary and should not hesitate in taking action if something is unethical or something wrong is happening within the trust. All right, Katie, if you could do the next slide. All right, there's also a similar provision for a petition that's filed in bad faith for trust, and that's contained in Probate Code Section 15642D. So keep in mind that there is that possibility that attorney's fees could be awarded against someone who files a frivolous petition to remove a trustee. All right, next slide, Katie. Keep in mind what the best interests of the parties are. Probate Code Section 16403 imposes liability on a successor trustee for failure to remedy breaches of trust by his or her predecessor. Now, normally, you're going to find that cause of action in that petition for removal, which asks for a surcharge. So you pretty much covered the grounds for that. But the reason why I wanted to get this slide in is there is a note in that commentary, and I'm going to read that note. It's on the bottom right-hand corner. Quote, in certain circumstances, it may not be reasonable to enforce a claim against a former trustee depending upon the likelihood of recovery and the cost of suit and enforcement. And I can tell you that many times sitting on the bench, and I've talked to my other colleagues while I was on the bench in probate court, that during the course of the proceedings, we would have these bubble thoughts of, oh my God, all this litigation, we're really we're really destroying the corpus of the trust. And at some point in time, it doesn't make sense. So think about the possibility that maybe you shouldn't follow up on some of this litigation. If you have some questions about it, file a petition for special instructions so that you don't get in trouble. Lastly, I want to cite something from a country Western musical song, Casey Musgrave, the song called Family is Family. And I'm not going to sing it because I don't have my country hat right now, but I just want to mention a few verses. Okay, so she sings, family is family, in church or in prison. You get what you get, and you don't get to pick them. They might smoke cigarettes like chimneys, but they'll give you their kidneys. Yeah, friends come in handy, but family is family. They're there when you're married, divorced, or remarried. You fall out of touch, but then someone gets buried, and you're right back together like no time has ever gone by. You might look just like them, but that doesn't mean you like them, but you just love them. So with that closing remark and song, just keep in mind that you're doing a good job and representing your client, but sometimes take off your litigation hat and try to do what is best for your client and the rest of the family to end the struggle and the litigation that has been going on for a long time. So with that, I'll turn it over back to Katie.
Thank you so much to all of our speakers for your insights and foresights. I see that Judge Moberly and Judge Schulte did some answering of some of our questions, but we do have a couple of minutes here at the end if you would be interested in answering any of our final questions that we have submitted.
Katie, before we go to those three, because I answered the one, I want to make sure I was right, because somebody had asked about, because I know this is being recorded and they wanted to know if they could listen again. And I think the answer is yes. And we have a YouTube channel. Do they go to YouTube or do they go to our website? I know the materials are posted on the website because there were also a few people having trouble accessing the slides, I guess. So.
Yes, thank you, Judge Schulte. ADR Services Inc. did record this, and all of our presentations are made available after the fact for self-study credit. We do post them on our YouTube channel. So if you go to YouTube, you can just search ADR Services and our channel will pop up there. Currently, you can watch the first episode in this series, which focused on conservatorships, in addition to our episode from 2021 featuring Judge Schulte here, along with a few of our other neutrals going over different ADR options. And you are welcome to go to our YouTube channel to watch those. You can also find any of the materials after the fact in the description of the YouTube video or on our website, adrservicesinc.com or adrservices.com. There's a CLE page where you can scroll through the prior presentations. This one should be up within the next couple of weeks as well. So we do have some questions here, specifically for Judge Schulte. Can you expand on the trustee's absolute discretion regarding to discretionary distributions to beneficiaries? What limitations are there on the absoluteness of the discretion with the trustees does not set any standards?
Well, if the question is that the trust doesn't set standards, or I'm not quite, it's a very good question that could take a long answer, so I don't want to do that. But 16, I didn't have it as a slide, and I know I kind of went by it pretty quickly just because of time, but 16081 of the probate code, and I'm sure that you're familiar with it. Joy? Yeah. Because of your question is a very good one, but basically talks about absolute and sole uncontrolled discretion, but still the trustee is always limited by acting as a fiduciary standard of care under the circumstances, not acting in bad faith and not disregarding the purposes of the trust. That sounds like that's really kind of like squishy, but it's sort of the nature of probate and what we judges like about it. The big discretion word and equity. So I don't think there's a real, unless anybody else of my brilliant colleagues has a better answer, that's about the best I can give you.
We do have a question, a general one. What are some resources for finding professional fiduciaries?
Let's see, any.
Any thoughts on finding professional fiduciaries available? Any resources, folks?
I mean, I know in Orange County, we have, I think the court maintains a list of the ones that that are approved.
Sure. By reputation too.
Yeah, yeah. I've never had to look for one. Usually pretty happy with the ones that they bring. Anybody else thoughts? I think there's a professional fiduciary bureau. I think if you just Google finding professional fiduciaries, but I know that our court has, I don't know if it's because I've retired 5 years ago and I left probate 4 years before I retired, but may continue taking overflow, but I haven't really seen what the list is. I just kind of have in mind who I know that are some of the ones that the court's going to give a lot of credence to. I don't know what they do in LA County, Judge Suzuki.
Well, I did see a list and it's fairly extensive actually, but I just saw it from the bench side. I don't know how the public would necessarily access it. I'm sure it's available. I would talk to the clerk of the specific department and I'm sure they'll give you that list.
Oh, and here's somebody, Barbara Simon posted PFAC, Professional Fiduciary Association, and there's a website there. Thank you, Barbara. That's great.
ADR Services, Inc. has been your unwavering partner in alternative dispute resolution. But as the world changed, so did we. From virtual and hybrid hearings to our ongoing on-demand CLE program, ADR Services, Inc. continues to keep resolution and legal education at the forefront, woman-owned and operated from the start. There is someone for every situation. We are ADR Services, Inc.